Good afternoon. My name is Vladyslava Kaplina. I am a guest lecturer at the University of Lisbon School of Law. And today I would like to talk to you about international humanitarian law and business and respond to a question, is there a bridge? Business always operates in complex environments due to a number of subsidiaries, production plants, employees, suppliers, different jurisdictions involved. And the situation gets even more complicated when it comes to companies operating in conflict-affected areas. There, business faces danger of being complicit in human rights violations and abuse, and even war crimes and crimes against humanity. Even when company attempts to declare its neutrality due to its detachment from the political processes in a country, believing that it is simply conducting economic activities, it nevertheless influences the events taking place in the country. According to the UN Working Group report, Business, Human Rights, and Conflict-Affected Regions Toward Heightened Actions, conflicts are on the rise around the world. For instance, since the adoption of the UNGPs in 2011, the number of civil wars has almost tripled, with a six-fold increase in combat-related deaths, peaking in 2016 when conflicts broke out in 53 countries. Moreover, more than 71 million people have been forcibly displaced by war, violence, and persecution, resulting in the world's largest humanitarian crisis since the end of the Second World War. As it is known, as soon as a conflict starts, the norms of international humanitarian law are applied. And then comes the question, what should business do in conflict-affected areas? Whether it has any obligations and protections under the Geneva Conventions, and what are the consequences for IHL violations committed by business. My presentation aims at looking into these questions and responding to them. For this purpose, the presentation is divided into 4 sections. The first one gives a brief overview of the phenomenon of armed conflicts and the scope of the IHL application. The second one reflects on whether IHL rules are applicable to business, while the last two discuss the possible ways for companies to contribute to IHL violations and the risks they face for operating in conflict-affected areas, respectively. The jus in bello, or the so-called humanitarian law, applies in all cases of declared war or any other armed conflict that may arise between 2 or more of the high contracting parties, even if the state of war is not recognized by one of them. It shall also apply to all cases of partial or total occupation of the territory of a high contracting party, even if the said occupation meets with no armed resistance, in accordance with Common Article 2 of the Geneva Convention. And finally, the provisions of the Geneva Convention should be applied in the case of armed conflict not of an international character occurring in the territory of one of the high contracting parties, in accordance with Common Article 3 of the Geneva Convention. Summarizing the IHL application, it should be mentioned that it covers 2 areas: the protection of those who are not or no longer taking part in fighting, and restrictions on the means of warfare, in particular weapons, and the methods of warfare, such as military tactics. The purpose of the IHL is to limit the suffering caused by war by protecting and assisting its victims as far as possible. The law therefore addresses the reality of a conflict without considering the reasons for or legality of resorting to force. It regulates only those aspects of the conflict that are of humanitarian concern. That is why it is known as jus in bello, or law in war. Its provisions apply to the warring parties, irrespective of the reasons for the conflict and whether the cause upheld by either party is just or not. As for the application of the rules, it is important to mention that the provisions of IHL are not voluntary. They have binding universal force. Anybody who is involved in and or linked to armed conflict has certain responsibilities under IHL. Thus, it is applicable to states, international organizations, national liberation movements, parties to the non-international armed conflict and individuals, including companies, their corporate personnel and executives whose activities are closely linked to an armed conflict. The discussion about the application of IHL brings us to its two crucial principles, which are considered some of the most important ones: the principle of equality and reciprocity. The first one means that all parties, those that are engaged in both an international and non-international armed conflict, have equal obligations under international humanitarian law. The principle can be derived from the preamble of the additional protocol to the Geneva Convention, which proclaims that the provisions of the Geneva Conventions must be fully applied in all circumstances to all persons who are protected by those instruments without any adverse distinction based on the nature or origin of the armed conflict or on the causes exposed by or attributed to the parties to the conflicts, and the Article 96, Part 3 of the same additional protocol. The second one can be divided into the so-called negative and positive reciprocity. The negative one can be derived from the Article 1 of the additional protocol to the Geneva Convention. The commentary to it shows that a party should be prevented from claiming to be exempt from the obligation to respect a particular provision or the protocol as a whole because an adversary had not respected this provision or the protocol as whole. As for the positive reciprocity, it is used by the parties to mutually encourage each other to go beyond what is laid down by humanitarian law. As it has already been mentioned above, IHL is applicable to different subjects, among which parties are to international or non-international armed conflicts and individuals. Here we come to a question whether it is applied to business, which will be discussed in the next part of this video. So we should start by saying what should companies' behavior in peaceful times be. In international human rights law, companies have internationally established responsibilities to respect human rights under the United Nations Guiding Principles on Business and Human Rights, or as I previously mentioned and will mention in this video, the UNGPs. Principle 17 of this document proclaims that in order to identify, prevent, mitigate, and account for how companies address their adverse human rights impact, business enterprises should conduct human rights due diligence. This process allows companies to assess human rights impact in order for an enterprise to maintain a true picture of its human rights risks over time, taking into account changing circumstances. Taking into account that the risk of gross human rights violations and abuse is heightened in conflict-affected areas, action by states and due diligence by business should be heightened accordingly, as it is proclaimed in the Principle 7 of the UNGPs. Additionally, Principle 23C highlights that in all contexts, business enterprises should treat the risk of causing or contributing to gross human rights abuses as a legal compliance issue wherever they operate. Thus, companies should conduct heightened human rights due diligence. In comparison to the classical human rights due diligence, which helps businesses to know how to avoid or minimize human rights risks to people, heightened human rights due diligence strengthens the understanding of the context in which businesses operate and ensures that companies' activities do not contribute to violence by identifying flashpoints, potential triggers, or the forces that are driving the conflict. This process includes a conflict-sensitive approach that complements the ongoing human rights due diligence. For the purposes of the OECD guidelines, contributing to an adverse impact is interpreted as a substantial contribution, meaning an activity that causes, facilitates, or incentivizes another entity to cause an adverse impact and does not include minor or trivial contributions. In addition to conflict sensitivity, heightened human rights due diligence incorporates atrocity prevention, transitional justice, and peace-building frameworks into due diligence processes. Here, we come to a case where companies are to comply not only with the responsibility to respect human rights under UNGPs, but also with the rules established by international humanitarian law, which are obligatory for those actors who find themselves on the territory of an armed conflict. This comes as a contrast to the voluntary commitments of companies in human rights area, like human rights due diligence, corporate social responsibility, etc., which do not substitute the necessity of compliance with IHL when it comes to operation in conflict-affected areas. Indeed, conflict analysis and respect for IHL is complementary to the values and goals of established human rights frameworks. Jonathan Collieb, while discussing the necessity of IHL norms in business activities, stresses that human rights should not be understood by reference to human rights treaties alone. In conflict-affected areas, responsible corporate best practice must include respect for both IHL and international human rights law norms. End of quote. And this comes as no surprise, since any armed conflict poses the greatest threat to the very existence of human beings, not only to guarantees of their rights. Besides, business attention to international humanitarian law will help them to better understand conflict-affected areas where they operate, to mitigate risks of gross human rights violations, and to better protect their personnel and assets. Human rights and IHL should be key elements of companies' due diligence and risk management activities in areas. By failing to adequately integrate IHL and conflict sensitivity into due diligence and other policies, companies risk harming the communities in which they operate and expose themselves to unnecessary operational, financial, and reputational risks, as well as significant criminal and civil liability. Here comes another crucial question. What is the place of IHL and in conflict-affected areas and in business that operates on such territories? As the International Committee Fred Cross mentions, the IHL is relevant for companies since it protects their staff, local, expat, or outsourced, as well as their property. Through the principle of the immunity of the civilian population, all civilian factories, offices, vehicles, lands, and resources are also protected from deliberate or indiscriminate attacks, as well as from pillaging and violations of private property, which must be returned or indemnified at the end of the conflict, in accordance with Article 48 of the Additional Protocol to the Geneva Convention, Article 13 of the Second Additional Protocol, and Article 51, Parts 4 and 5 of the Additional Protocol, and 52 of the Second Additional Protocol. Thus, it is of utmost importance for companies to include such rules into their human rights policy. However, the ICRC admits that even though many companies have adopted human rights policies, very few have yet included policies on international humanitarian law. Moreover, the Geneva Conventions proclaim additional protection for the business personnel. Among such protection, we can find protection against violence to workers' lives, health, and physical or mental well-being, protection of workers as civilians deprived of liberty. If a business enterprise staff is charged with criminal offense linked to an armed conflict, the essential guarantees of independence and impartiality are proclaimed. Besides, the Geneva Convention sets forth additional protection for companies' property and compensation if the property is seized by the occupied power. Finally, it should be mentioned that the IHL establishes criminal and/or civil responsibility for companies in case of non-compliance or complicity with any violation of IHL rule. For example, in a lawsuit filed against Royal Dutch Shell for its actions in Nigeria in the 90s, the company was not only accused of environmental and human rights violations for oil spills in the Niger Delta, but also for backing the armed forces that were oppressing and repressing the protesting local communities. As we have already seen, and we will stress it once again in this video, nowadays the fact that the company has to deal in its operations as a producer, supplier, buyer, etc., with conflict-affected areas does not come as a surprise. Taking into account that there are more than 110 armed conflicts around the world that are present on every single continent, and that business is pretty much present in every country in the world, earlier or later, these companies will have to deal with operations in conflict-affected areas. Companies from different sectors, banking and finance, oil and gas, food and beverage, technologies and telecommunication, pharmaceuticals, chemical, and so on, are exposed to these conflicts. All of them may one day face a risk of either breaching IHL rules themselves while operating on the territory of a conflict-affected area, or a risk of helping third persons do so. They may not only cause harm to human rights and freedoms, livelihood of a society that finds itself on such area, but also have significant reputational and financial damage as well as legal accountability. Overall, the IHL grants protection to companies, but at the same time, it imposes certain legal obligations on the executives and staff of these companies that are closely linked to the conflict. Specifically, issues related to the provision of security services to companies in this situation of conflict, either public or private, requires special attention. Here comes the time to look deeper into the question of what it means for business to be closely linked to an armed conflict. A quick example that comes to mind would be when business personnel is caught up in direct violation of international humanitarian law, like, for example, killing or harming civilians, destroying civilian property, and so on. Another example would be where a company works with an armed group involved in, for example, exploiting natural resources or purchasing natural resources from that group, which results in indirectly supporting or furthering the war effort. Moreover, business activities may be considered closely linked even if they do not take place during actual fighting or on the physical battlefield, and even if the business did not actually intend to support a party to the hostilities and claimed to keep neutrality. David Hughes suggests 3 ways in which business actions may be linked to or could be perceived to be linked to an armed conflict. And direct violation of IHL by breaching laws of war. For example, companies' security contractors attack and kill civilians. What happened in a famous Blackwater case that took place in Baghdad, Iraq, during Iraq War in September 2007. Second way is contributions to IHL violations committed by others, where business plays a secondary role and aligns with the conduct of others, parties of the conflict, and or willfully ignores the possible consequences of being found complicit in IHL violations or war crimes. For example, a company produces missiles and sells them to a party of a conflict which commits war crimes with this weapon or violates IHL in some ways by using this weapon. One more example from a non-international armed conflict and the company that wants to start a mining activity in the country. Such activity will certainly influence local communities because they will have to be displaced. Thus, they protest the development of the mine. Since business needs force to displace people, it pays the government to involve national armed forces to forcefully displace civilians. And the third way is indirect or accidental contribution to IHL violations. For example, a business operating in a country aggressor pays taxes there that go to purchase weapons and supplies for war efforts. This does not mean that business directly violates or supports third parties' violations of IHL. Rather, its conduct has an incidental impact, usually without the relevant personnel's knowledge or intent. Notably, though, there may still be risks, including possible criminal and civil liability risks. To prevent the 3 above-mentioned scenarios, business should be proactive and listen to what IHL rules say, how they influence or may influence a company of a certain sector, as well as the geographical context of the company's operation. One more important thing for business to remember. IHL has as one of its goals treating people who find themselves on a territory of a conflict with respect and dignity. Moreover, IHL tries to help achieve at least some level of humanity during an armed conflict. Thus, business, by understanding this, also understands why and how it should contribute to upholding or improving humanity if an armed conflict occurs on the territory of its operations. Besides, IHL provides a range of protections to affected businesses, since people and buildings not involved in the fighting are protected under its framework. As long as the business maintains its, let's say, civilian status, all of its personal facilities and assets will be entitled to protection against armed attacks. This is one of the benefits for business that takes into account IHL while operating in conflict-affected areas. And it is not just some benefits focused on businesses themselves, it is also about leverage, since we cannot deny the fact that business can bring changes and can influence for change, even in conflict-affected areas, sometimes even greater than during peaceful times. Corporations are a huge source of income, are big employers, service and good providers, taxpayers, and have their strategic value. Business undoubtedly should use this leverage to engage with stakeholders and deliver a certain message to parties of a conflict. Now, let's talk about how companies can contribute to IHL violations. At previous several minutes of this video, I mentioned that business actions may be linked to an armed conflict and IHL violations, and that better understanding of IHL may help business identify and mitigate those risks. Next, we should mention some of the most relevant conflict-related situations for business and how it may contribute to IHL violations. It's direct and indirect harms to civilians, forced displacement of civilians, assets and property plundering, damage to the environment, and military occupation. Next, let's have a look briefly into each one of these situations separately, starting with the direct and indirect harms to civilians. The Fourth Geneva Convention protects civilians in areas of armed conflicts and occupied territories, as well as the second additional protocol to the Geneva Convention. For instance, Article 13 of the first document states that the provisions of Part 2 cover the populations of the countries in conflict without any adverse distinction based in particular on race, nationality, religion, or political opinion, and are intended to alleviate the sufferings caused by war. Furthermore, Chapter 2 of the additional protocol establishes measures in favor of women and children, for example, in Article 13. Thus, business operating in conflict-affected areas should ensure compliance with these rules and that it does not harm civilians directly or indirectly. Besides, it should take precautionary measures regarding its personnel, who may be considered to be directly participating in hostilities. This concept entails that persons carry out acts that aim to support one party of the conflict by directly causing harm to another party, either directly inflicting death, injury, or destruction, or by directly harming the enemy's military operations or capacity. If and for as long as civilians carry out such acts, they are directly participating in hostilities and lose their protection against attack. Some of the examples of actions through which companies can be linked to IHL violations are the ones where they provide financial or material support to a party to the armed conflict, for example, through the provision of jet fuel, which is then used in airstrikes on civilians, in the famous Colmar case, provide advice to one of the armed forces on the conduct of hostilities, for example, by providing technical advice on how to engineer environmental damage by destroying a dam. Or manufacture or supply prohibited weapons or supply weapons to end users who the business knows will violate IHL, like it happened in Van Anrad case and the BAE Systems case. And insist in mobilization efforts by providing lists of eligible employees who then go on to commit war crimes. For example, the cases of Raiffeisenbank, Auchan, and Buse Unicem in Russia in 2022 and 2023. Next follows the forced displacement of civilians. IHL does not give a specific definition of this term. As ICRC mentions, the IHL uses a variety of terms that can collectively be referred to as acts of forced displacement. For instance, Article 49, Part 1 of the Forced Geneva Convention prohibits individual or mass forcible transfers, as well as deportations of protected persons from occupied territory to the territory of the occupying power, or to that of any other country, occupied or not, regardless of their motive. However, the second paragraph of this article permits total or partial evacuation of a given area if the security of the population or imperative military reasons so demand. As it has been mentioned previously in this video, forced displacement may occur because of either a deliberate strategic move by one party to an armed conflict or due to consequences of an armed conflict. For instance, the violence in Colombia during 1995-2005, studied by the ICRC, shows that the forced displacement of civilians during the conflict took place as part of a military involvement and as a consequence of violence and fighting. Interestingly, there may occur situations where state armed forces and non-state armed groups employ to force civilians out of their homes. They do not explicitly order displacement, nor do they organize it, but they provoke it deliberately by using methods such as direct attacks against civilians, sexual violence, public beatings, threats against people's lives and safety, and direct attacks against civilian objects, including homes, places of work, infrastructure, and religious and cultural property. In addition to other violations of IHL, these cases may also amount to forced displacement as prohibited by IHL. An example of a company's involvement in forced displacement is the famous Lundin case. There, the company allegedly paid the Sudanese army and non-state armed groups to forcibly displace the local population from oil-rich areas in order to secure their operations. Between 1997 and 2003, almost 200,000 civilians were forcibly displaced and thousands died. The company was and is now tried in Sweden for complicity in war crimes committed on a territory that nowadays is South Sudan. The next situation relevant for business is assets and property plundering. Articles 33 and 34 of the Forced Geneva Convention prohibit pillage, reprisals, indiscriminate destruction of property, and the taking of hostages. Additionally, Rule 52 of the Customary International Humanitarian Law prohibits pillaging in both international and non-international armed conflicts. The statute of the International Criminal Court proclaims that destroying or seizing the enemy's property, unless such destruction or seizure be imperatively demanded by the necessities of war, constitutes a war crime in international armed conflicts. There is also a specific practice collected with respect to the pillage of cultural property and of property of the wounded and sick, as well as dead, and persons deprived of their liberty. Pillage or plunder can be defined as the forcible taking of private property for private or personal use by an invading or conquering army from the enemy's subjects, which must be done. For businesses operating in conflict zones, the possibility of being involved in plundering may include the acquisition of private and/or state property and/or an asset that is unlawful because it was done through the use of threats, intimidation, or a position of power derived from the business's presence in the armed conflict. This is of a special importance for business that operates in the mining and/or oil and gas sectors. We have already heard about some cases where business was charged with pillaging. For instance, the case of Michael Gizadelier, a Belgian and American citizen who allegedly participated in enslavement as a crime against humanity and in the looting of blood diamonds as a war crime in Kono district in the east of Sierra Leone, during the civil war in the country between 1991 and 2002. It was alleged that the businessman was working with a rebel group, the so-called Revolutionary United Front, who needed him to export the diamonds outside of the country. Next, important situation where business may have its influence is the destruction of environment. And since it is indispensable to the survival of the world's community, IHL also aims at protecting the environment. The guidelines on the protection of the natural environment in armed conflict prepared by the ICRC reveal that most major armed conflicts between 1950 and 2000 took place in biodiversity hotspots, putting delicate ecological balances at risk. Countries experiencing conflict are also on the front line of climate change. 12 of the 20 countries that, according to the ND Country Index, are the most vulnerable to climate change are also sites of armed conflicts. If we look back at the armed conflicts that happened over the mentioned period, we will find lots of examples where nature was directly harmed. For instance, the use of herbicides during the Vietnam War, the burning of Kuwaiti oil wells during the 1990-1991 Gulf War, and the extensive deforestation during the conflicts in DRC. This all led to the necessity of heightened respect and protection of the environment. Companies can harm it directly by exacerbating pre-existing environmental and climate-related problems, and indirectly by, for example, participating in deforestation and mining on the territory of a conflict, providing advice and or service to a party of an armed conflict on power station construction, or sharing scientific knowledge on how to develop weapons that cause environmental harm. The last conflict-related situation that was mentioned on one of the previous slides is military occupation. As it is known and has already been mentioned in this video, the IHL rules apply not only to the armed conflicts, but also to the situations of occupation, which means that one state invades fully or partially another one and exercises effective control over the territory without the other party's consent. Taking into account the internationality of such conflict, the rules of the international armed conflict rather than a non-international one apply. Besides, Article 1, Part 4 of the additional protocol to the Geneva Conventions mentions that IHL rules also apply to the situations where people are fighting against alien occupation in the exercise of their right of self-determination. Interestingly, the IHL rules apply even if the occupation meets with no armed resistance, according to Article 2, Part 2 of the First Geneva Convention. The determination of the existence of an occupation is a complex process due to the absence of a definition of occupation in the Geneva Convention. Instead, the notion of occupation has only been sketched out by Article 42 of the 1907 Hague Regulations, which reads, quotation, territory is considered occupied when it is actually placed under the authority of the hostile army. The occupation extends only to the territory where such authority has been established and can be exercised, end of quote. Businesses operating on an occupied territory must take into account IHL rules, since the occupied territory is also in a high risk of human rights violations and abuses. Moreover, the conflict-related situations that have already been mentioned at the beginning of the video can also occur on an occupied territory, such as forced displacement, pillage and destruction of private property, exploiting natural resources, etc. Probably the most famous case of occupied territories is Palestine, which has been occupied by Israel since 1967. Israel builds settlements on the Palestinian territory and displaces Israeli citizens there. Quite a few foreign governments, as well as the UN, recognize Israeli control over the territory as occupation. For instance, the UK government released a guidance on the risks for the business in the occupied territories. It stresses that, quotation, there are clear risks related to economic and financial activities in the settlements, and we do not encourage or offer support to such activity. Financial transactions, investments, purchases, procurements, as well as other economic activities, including in services like tourism in Israeli settlements or benefit in Israeli settlements, entail legal and economic risks. Stemming from the fact that the Israeli settlements, according to international law, are built on occupied land and are not recognized as a legitimate part of Israel's territory. This may result in disputed titles to the land, water, mineral, or other natural resources, which might be the subject of purchase or investment, end of quote. The international organizations and NGOs around the world have been tracing the involvement of foreign companies in Israeli activities on Palestinian territory, especially ones related to settlements. Thus, they have found out that companies such as TripAdvisor, Booking, Airbnb are profiting from and contributing to human rights violations that happen on this territory. TripAdvisor has an archaeological site listed as a tourist attraction without warning visitors that it is managed by settlers. The visitors to the site make financial contributions to the neighboring settlement that manages the ruins. A visitor center serves as a showcase for production and goods that are grown or manufactured by settlers from the surrounding area, including wine, herbs, olive oil, and handicrafts. Same story with the tech giant Hewlett-Packard. NGOs from all over the world highlight companies' role in providing key services and technology infrastructure that enable the Israeli military occupation of Palestinian lands and suppression of Palestinian human rights. The above-mentioned behavior by companies in conflict-affected areas pose certain risks to companies, which will be discussed over the next several slides in this video. So there are three groups of risks. Operational risks that are related to the risks of loss from inadequate internal process, practice, and system, or from external events. Reputational risks. A business reputation is decreasing due to the rising negative perceptions on the part of customers, shareholders, partners, investors, regulators, and community in general. This type of risk may negatively influence companies' value and profits. And the third group of risk is liability risks that constitute companies' responsibility for the damages resulting from IHL breaches. It includes both criminal and civil liability and may even include other types of liability. So now let's have a closer look at every single one of these groups. So the first is operational risks. Here we should mention that they arise from the fact that a company has physical presence or suppliers in conflict regions. Operational risks summarizes the uncertainties and hazards a company faces when it attempts to do its day-to-day business activities within a given field or industry. Such operational risks for businesses in conflict areas may include security and safety risks for staff and company's property, difficulties in retaining stable workforce, interrupted operations and supply chains, involvement in criminal activity, and decrease in the value of company assets. We can find an example of the consequences of the lack of operational risks analysis in companies' operations in the Russian aggression against Ukraine that started in February 2022. 1 month into the full-scale invasion, a missile strike on Kyiv city center destroyed one of the biggest malls of Ukrainian capital and killed at least one Leroy Merlin Ukrainian employee who was at the premises during the attack. Another example is the case of a decree signed by the Russian president in April 2023. It authorizes a temporary control over foreign companies' assets based in Russia. Such temporary administration is to be handled by Russian Federal Agency for State Property Management, or as it is called in Russian, Rosimущество. Since April last year, 4 companies have already fallen victims of this decree, among them Unipro with Fortum in April 2023 and Carlsberg with Danone in July 2023. Interestingly, according to the decree, it does not deprive owners of their assets. The external management is a temporary measure, which just means that the owner does not have rights to take management decision. From a civil law perspective, the owner just loses the power to dispose the property, but keeps the other two, possession and use. As for the reputational risks, we should stress that it has the effect of reducing public trust in a company. It may have a detrimental impact on a company's reputation and lead to negative perceptions by customers, shareholders, partners, investors, media, and other internal and external stakeholders. Such risks may include negative public and media attention, divestment of investors and decrease in share prices, cessation of business relationships, boycotts from customers, being target of CSOs, adverse impacts on operations far from this specific conflict-affected area, loss of new opportunities and markets. Just to exemplify risks for companies, we can mention a recent case of Mondelez International, a famous American confectionery and other food products company, which continued operations in Russia since the beginning of the full-scale military invasion of Ukraine, and moreover tripled its profits there. In late May 2023, it was designated by the Ukrainian National Agency on Prevention of Corruption as a war sponsor. 2 weeks later, the company faced a Nordic backlash over continued business operations in Russia. SAS Airlines and Norwegian Air, Railway Group SJ, hotel chain Strawberry, retail Elkjøp, shipping group Fjordline, and the Norwegian Football Association were among those announcing that they would stop selling Mondelez products, which have been their official partners. Moreover, in January 2024, Sweden's Royal House announced the removal of Mondelez's products, Marabou, from its list of suppliers because of the NACP, International Sponsor of War list. Lastly, we should discuss liability risks for companies. If we look back at the history of humankind, we will find examples of companies being brought to responsibility for contributing to gross human rights violations, war efforts, and collaborating with armed forces. It all started with the so-called economic cases after the World War II, when German business executives from heavy industry and chemical sector were tried as well for their collaboration with the Nazi regime since 1930s and up until the end of World War II. It was believed that the businessmen were among those who financially and politically supported Adolf Hitler and his arrival to a position of Chancellor of Germany in 1933. They accepted the new Aryanization processes at their entities by firing Jewish employees, seizing foreign industrial property in countries occupied by Nazi, and by using forced labor. The economic case had several main aspects. The prosecution believed that some industrialists had played a role in the conspiracy to launch an aggressive war. Most industrialists have been involved in the Aryanization of industry. Some industrialists took advantage of plants and other property that had been occupied by the country, and business recruited and deployed around 5 million slave laborers, part of whom had been worked to death labor supplied by the Nazi extermination camps. The Flick, the IG Farben, the Krupp, the Ministries, and the Zyklon B cases will forever stay in history as the first trials of business for complicity in human rights abuse and international crimes. We should start by understanding what the phenomenon of complicity is. The commentary to Principle 17 of the UNGPs mentions that complicity may arise when business enterprises contribute to or is seen as contributing to adverse human rights impacts caused by other parties. Complicity has both non-legal and legal meaning. In the first one, business enterprises may be perceived as being complicit in the acts of another party where, for example, they are seen to benefit from an abuse committed by the party. And as for the latter, the commentary refers to the fact that most national jurisdictions prohibit complicity in the commission of a crime, and the number allow for criminal liability of business enterprises in such cases. The weight of international criminal law jurisprudence indicates that the relevant standard for aiding and abetting is knowingly providing practical assistance or encouragement that has a substantial effect on the commission of a crime. The key word is knowingly, meaning that a company is complicit in human rights violation if it knows it is providing assistance to an actor and the substantial effect of the assistance results in a human rights violation. Interestingly enough, at the national level, the main focus falls on knowledge, intent, and causation. Summarizing, we should outline the key elements of complicity, among which actus reus, what a company and or business person has done, mens rea, how close to the abuses in time and space the company and or business person was, and mental element, the state of mind of a person when they acted or refrained from acting. This mental element consists of 3 test standards, among which knowledge, which was mentioned above, and which means that a company and or business person knew or should have known about the violation being committed. This standard was applied, considered sufficient to hold company accountable in economic trials of German industrialists after the World War II. It was also applied by International Criminal Tribunal for Rwanda in Akayesu judgment, by the International Criminal Tribunal for former Yugoslavia in the Frunzia case. It can also be traced in the formulation of the Article 25, Part 3D in the Rome Statute of and the customary IHL. And the second is intent, whether the company and or business person share the intent of the main perpetrator. And the last one, purpose, whether they have acted purposefully. The so-called compromise between the first 2 standards can be found in the Article 25, Part 3C of the Rome Statute, and some cases in the USA, such as the Lisbon case. Lastly, we should mention that to be able to sue company for the violation of IHL rules, 3 fundamental elements of civil liability should be met: a wrong, damage, and the causal relationship between the first 2. Such violations can occur as a result of companies' actions or of actions and others, companies' employees or other entities, other companies, armed groups, or even a state. We can find some cases where business have already been charged and found complicit in war crimes. Fortunately or not, so far, such cases have mostly happened in national jurisdictions, since the adopted version of the Rome Statute excluded the proposal to try companies in the ICC. However, we should stress the fact that the Article 25 of the Rome Statute permits prosecution of companies' directors. Although there are no cases against businessmen in the ICIC, the prosecutors of the ICIC do support the idea that of an amendment to Rome Statutes in order to allow prosecution of corporations. However, some of the international tribunals did hear cases of businessmen involved in human rights violations and abuses. The tribunal that demands our close attention is the International Criminal Tribunal for Rwanda. One of the businessmen indicated under the proceedings was Felicien Kabuga, a multimillionaire businessman from Rwanda and the president of the Comité d'initiative of Radio-Télévision Libre de Mi-Collines, a creator of the National Defense Fund, which allegedly funded Interahamwe, a youth militia group which was physically executing the genocide in Rwanda, and the creator of a private radio station, Radio Machete, which played an important, in a negative way, role in genocide as well. He was indicted in 1998 for his alleged role in spreading anti-Tutsi messages with the aim of promoting crimes against Tutsis during genocide, complicity of genocide, attempt to commit genocide, conspiracy to commit genocide, incitement or to commit genocide, and crimes against humanity for acts of extermination and persecution. This case marks a modern approach to the reality in which corporate entities can commit acts of genocide and that collective accountability for mass violence does exist. Despite the breakthrough in holding business accountable for involvement in atrocities, the ICTR was criticized for the fact that the prosecution had not paid any attention to foreign companies involved in the country, e.g., banks and arms companies. Descending to the national level, we can notice that in recent times, the domestic courts have become quite proactive in what concerns corporate prosecution. National legislations allow states all over the world to hold companies criminally liable for human rights and IHL rules violations. Besides, the adoption of the Rome Statute and the establishment of the ICC catalyzed states to introduce legislation on international crimes that are taken together with national law of criminal law permits the states to prosecute companies for international crimes. Dutch courts are on the forefront of holding a businessman accountable for contributing to human rights violations in conflict-affected areas. Among such cases are Frans van Anraat and Goes Kovenhoven. The first one was tried and convicted for selling chemical substances, Todiclicol, to Saddam Hussein's regime in Iraq during the 80s, which was later used in the manufacture of mustard gas used in the war against Iran, and as a part of genocide of Kurdish population in northern Iraq. While the second one was tried and convicted as well for aiding and abetting for crimes committed by former Liberian President Charles Taylor. Several cases that should be highlighted here are Anvil mining case in Australia, where the Australian company got in a prosecution spotlight for the alleged role in Congo massacre of 70 people in 2007. Lafarge case, the company was accused of making arrangements with Islamic State and several other armed groups in order to keep its Jalabi cement factory open and running between 2012 and 2014 in northeastern Syria. And Ameses case, the company is being accused of complicity in Libyan regime's torture by providing software technologies that permit the state to track, identify, locate, and repress political dissidents. Case that is also happening in France. And lastly, the concluding remarks. Most armed conflicts, both past and present, are based on or are at least closely related to the economic interests of the parties to such confrontations or stakeholders involved in the conflict. Companies doing business in conflict-affected areas or trading with businesses that are involved in armed conflict face a number of complex human rights risks and may also be directly or indirectly involved in crimes that could be qualified as international crimes, such as war crimes, crimes against humanity, or genocide. In this situation, the environment becomes volatile, and thus the classical due diligence process gets less efficient by the fact that the context of the conflict is subject to rapid changes. That is why companies should conduct heightened human rights due diligence, which adds to the ordinary human rights due diligence a conflict-sensitive analysis. In addition to the heightened human rights due diligence process, companies are to comply with international humanitarian law rules, since it will allow them to better understand the situation in which they operate, what guarantees and obligations they have in such complex environments. Companies, their personnel and property which are not directly linked to a conflict enjoy the protection under Geneva Conventions from deliberate or indiscriminate attacks, as well as from pillaging and violations of private property. Besides, to the fact that companies have protection under the IHL, compliance with its norms will help businesses prevent harming the communities where they operate and expose themselves to unnecessary operational, financial, and reputational risks, as well as serious criminal and civil liability at both national and international levels. Since the military tribunals in post-World War II world, the attempts have been made to hold accountable businessmen involved in human rights violations by international tribunals, among which International Criminal Tribunal for Rwanda. Additionally, companies' directors can be tried by International Criminal Court under Article 25 of the Rome Statute. Regardless of some developments at the international level, this video suggests that in recent times, national courts have become much more active in bringing companies to criminal liability for violations of international humanitarian law and human rights. The importance of the development of the possibility of bringing legal entities to criminal liability is explained by several reasons. First, that crimes committed by companies cannot always be reduced to one person, even if it is a director. Second, direct punishment of a company has long-term results, since it is the persecution of the corporation that can serve as an additional incentive for the implementation of heightened human rights due diligence processes, which can positively affect companies' behavior in the conflict zones. And thirdly, criminal prosecution allows access to corporate assets as a means of reparation for victims. Lastly, it should be noted that nowadays countries also tend to accept the principle of universal jurisdiction over violations of international criminal law, which allows them to prosecute international crimes even when such crimes are committed outside national territory and regardless of whether the perpetrator or victims are citizens of that state or not. On this slide, you can find some useful bibliography in case you would like to learn more about the topic. And thank you very much for your attention.